Welcome to today's presentation on title examination, running the chain of title. Boudreaux and Thibodeau, they was walking down the street and they saw a sign in a store that said wanted division order analyst. And man, they thought, man, I know a little bit of division. I think I could be a division order analyst. So they walked into the store, the oil and gas company, and the boss man said, well, now hold on a minute now. You know, you just can't walk in here and be a division order analyst. You got to take an exam. You got to take an examination. So they said, okay, that's fine. So they took an examination, the exact same test. They got the exact same grade on the test, and Boudreaux got the job. And man, Thibodeau, he was so mad at him. He said, you know, this is not fair, no. He says, man, how come we walk in and apply for the exact same job on the exact same day, exact same time, we take the exact same exam, we make the exact same grade, and Boudreaux gets the job. And so the boss man said, well, now, Mr. Thibodeau, now it's the way you answered your questions, you see. Let's look at Mr. Boudreaux's paper. See, on number 3 here, it says the answer is, I don't know. See, that's okay. Now let's look at your paper, Mr. Thibodeau. It says on number 3, it says, I don't know either. Okay. So I'm glad y'all like that. So today we are talking about a title examination, another type of examination. That's why that joke was a perfect segue. But we're talking about title examination. Now, what I want you to understand from a division order analyst perspective is I want you to understand the process that an attorney goes through to run the chain of title to create that title opinion, and the process that the landman goes through in order to determine who the mineral owner is. So I'm going to walk you through this presentation. This is very similar to the one that I do for the Professional Land Management Certificate Program. So all the issues that I'm going to identify are things that they are looking for when they run the chain of title. So let's begin with the agenda. And we'll start with a review. We'll start with a review of what it is to record an instrument, how to record an instrument, and then we'll talk about what we talk about when we say running title. And we'll talk about what letters patent is. You'll hear people say chain title all the way back to letters patent, or sometimes they'll say chain title all the way back to the sovereign. I want to make sure that you understand that. And then I want to give you a little brief understanding of how complicated this can get. For one reason, a different person can own the surface and a different person can own the minerals. And so that makes it very complicated for a landman or a title attorney to go through this. Then I'd like to give you some chain of title examples so you can see how the interest would be split out between the surface estate and the mineral estate. And then we'll go over what geology, what their contribution is, and what they give the landman in order for them to run the chain of title. Then we'll walk through the process of going to the county courthouse and seeing what the problems are there with finding these legal descriptions and the mineral owners. So from there, I want to then give you 10 steps to take to examine the chain of title. Now, this is from a landman's perspective. We'll talk about how a title attorney does it in a little bit, but I want you to know the whole process, and then I'll show you the shortcut that the title attorney takes. I shouldn't say shortcut, I should say the expedited method that the title attorney takes. And then I want you to know how to, as one of those steps is how to interpret title instruments, and we'll talk about the distinction between mineral royalties, a mineral conveyed or a royalty interest conveyed, as well as do some calculations. And then we'll wrap up with our final notes, and at the conclusion, we'll take any questions that you do have. Are there any questions about this agenda? Okay, well, let's then begin at the beginning. Now, we learned last module that if you have something that is dealing with real property, that is real estate, In order to protect your claim, in order to be binding against third parties, that instrument has to be recorded in the county courthouse. So I wanted you to understand how that recording takes place. First of all, you can either go to the county courthouse or you can mail in your original instrument. Typically, if you want to go into the county courthouse, you go to the county clerk's office and you say, I want to file this document of record. Those are the kind of the buzzwords. I want to file this document of record. Or sometimes they'll say, I want to file this. I want to just simply say, I want to record this. I want to file this of record. And what that tells the county clerk is that you want to have this instrument stamped with a volume and page number, or sometimes they have what's called a folio number. And the volume, whether it's volume and page or folio, is going to have a recordation date. And it's usually going to have some kind of a designation by the county clerk's office that it's been recorded, like a stamp or something. This volume and page stamp would be an example. So what the county clerk is going to do with that is they are going to file that in their records. And we'll talk about how their records are organized in a minute. Another way that you can record an instrument is that you can mail it in. Now, whether you mail it in or whether you deliver it in person, there is a fee that's charged. And different states and different counties, it's a different amount. But just to give you a ballpark, it's usually like $15 for the first page and then $5 for every page after that, something like that. That is what the payment is. And so you would then just file this with the county clerk's office, either mailing it in or coming in person. Now, what I used to do was I would show up with two originals. I would have the landowner or the mineral owner sign two leases. So we would have an original signature on both leases. I would hand one original to, or I would hand both originals to the county clerk's office. They would date stamp both of them, and then they would keep the original for their records. Well, today, in this digital age, everything that's recorded is now digitized. And so there's really not a need to bring in two original documents, because they are not keeping an original document. You are the one keeping the original document. They are keeping a record of that document. So that is how you record an instrument in a courthouse, or you can mail that instrument in. Okay, let's then look at what we talk about when we talk about running title. See, every document in here, and if you think about it, I like to use the analogy of in the Monopoly game. You know, in the Monopoly game, there were all these colorful cards that would tell you where, what properties you owned. And, sorry, I thought I lost y'all for a minute. But that's not, you know, when we're dealing with real property law in the real world, the records aren't that, the deeds aren't that colorful. But we are trying to determine, just like in that Monopoly game, whoever holds the card is the owner of the property. So we're trying to figure out who owns the mineral interest, who owns record title. So when we file an instrument of record, anytime there's any kind of transaction that affects real property, it's got to be in writing. And so what happens then is that you have a historical list of transactions that have occurred on a given property. So that is the chain of title, if you will, the record of ownership that's determined by looking at each instrument that's filed. It's like looking at history. Now, we refer to this as the chain of title or letters patent. Now, when we say letters patent, we're talking about when the federal government, that is the sovereign, you'll hear people say chain title all the way back to the sovereign. That's when the federal government gave the first instrument to the first homesteader. And so then we're going to chain, and that's going to be an instrument that's filed of record. And then whatever happens to person A, there's going to be another document, either a transfer to B or maybe a transfer to the heirs, which would be through probate. So we're just following this historical chronology of what happened to each instrument. And as we go, we're analyzing what exactly was transferred. So the chain of title is simply every one of these is considered a link in the chain of title. And the whole string of them is called the chain of title. Now, let's talk about letters patent. Any of you watch that show, Shark Tank? In Shark Tank, one of the main questions that the investors are asking, or that the sharks are asking, is, do you have a patent on this? And why is that important? Because if they don't have a patent, it can be copied. Anybody can use that invention to do whatever they want with it. In other words, the owner, the person that invented it, does not have unique ownership. It's not spelled out that this is the absolute owner. Well, when we talk about letters patent, it's sort of the same thing, because we're saying we are giving this person, we are giving them a patent, saying that they and they alone have the right to use this property. So let's talk about what is a letters patent. You will not find these formal instruments in the record title because they didn't have Xerox machines, you know, when we first started chaining title. So when you look at old records, it's literally someone took the document and hand wrote in the book, word for word, line for line, what's in that book. So there's really no way for you to see what a letters patent is, except that I happened to be at my grandmother's house one day, and I ran across this instrument called letters patent. And I said, what is this? And she said, oh, this was an instrument that my grandfather, so what's that, my great-grandfather or great-great-great-grandfather, when he received his first homestead. So I can show you what an actual letters patent looks like. And this is what it looks like. This is an old certificate. My grandmother had it laminated. And you'll see right here, it says homestead, certificate number, and it's got the number here. It's got this application number, and then down at the bottom, it gives the volume and page number. So this was pretty early on. This was in the 1800s, 1893, I believe. So volume 9, that's pretty early on. And so I would just like to walk through this instrument with you, since it's so rare that you would get to see one. And I want you to really have a concept in your mind of what we mean by letters patent. So it says, the United States of America, to all to whom these presents shall come, greeting. Whereas there has been deposited in the General Land Office of the United States of America a certificate of register of the Land Office at New Orleans, a certificate of, a certificate of the Register of the Land Office at New Orleans, Louisiana, whereby it appears that pursuant to the Act of Congress approved May 20th, 1862, quote, to secure homesteads to actual letters, there's the word letters, in the public domain, close parentheses, and the acts supplemental thereto. The claim of William Stoddard, this is my great-great-grandfather, has been established and duly consummated in conformity to the law for the, and then here it gives the property description, the northeast quarter of the southeast quarter and the southeast quarter of the northeast quarter of Section 8 and the south half of the northwest quarter of Section 9 in Township 8, South, Range 2, west of Louisiana Meridian in Louisiana, containing 160 acres and 1/1300 of an acre. Then it goes on to say, according to the official plat of the survey of said land, what is that word? Returned to the General Land Office by the Surveyor General. I think it's retained. Then it says, now know ye that there is therefore granted by the United States and unto the said William Stoddard the tract of land above described, to have and to hold the said tract of land with all the appurtenances thereof unto the said William Stoddard and to his heirs and assigns forever. And then it concludes with, in testimony whereof I, Grover Cleveland, check it out, President of the United States of America, have caused these letters to be made patents. There's your letters patent. And the seal of the General Land Office to be hereunto affixed. Then it says, given under my hand at the city of Washington, the 23rd day of August in the year of our Lord, 1893, and of the independence of the United States, the 180th, 118th, I think that's the Congress, by the President, Grover Cleveland, and then they have the Secretary's name and the Recorder of the General Land Office's name. Now, I don't think that this is actually Grover Cleveland's signature because it matches everything else that's in the instrument. So I highly doubt that Grover Cleveland was sitting and meticulously writing this out. But it's interesting, right? Because it is coming from the sovereign, and the sovereign is the United States government, who is represented by Grover Cleveland. So that is the concept of letters patent and of chaining title back to the sovereign. Okay, so now that we know that William Stoddard owns the property, we're going to start with this letters patent, and then whoever he conveyed to the next interest to, party B, that will be the first link in the chain. Will U.S. to William Stoddard, and then William Stoddard to B. So this is a link, and this is a link. I don't want to get too technical on you, but now it can get more complicated because when the government gave this to my great-great-grandfather, they were giving it to him as what we call fee simple, or sometimes referred to as fee simple absolutes. And what that means is, especially when we talk about it in an oil and gas contact, is that he was given the surface and the minerals. The surface and the minerals. And we get that from where he says, and all the appurtenance hereunto affixed. Appurtenances would be things like a barn or a fence, or it could mean the minerals, something that is a part of the land. So with that background, let me talk about a little bit about running the chain of title when we have different ownerships. So here we said this is called fee simple or fee simple absolute. But that fee simple absolute can be divided into a surface estate, and we call this a surface estate, and a mineral estate. So you may hear people say, who owns the surface estate, who owns the mineral estate? And of course, this all derives from real property law or real estate, okay? Now, in the case of my grandfather, these are owned both by him. So he owns the surface estate and he owns the mineral estate. But these estates can be severed. And if they're severed, we call that a split estate. And what happens in a split estate is that one person owns the surface and a different person owns the minerals. So this can happen if the landowner owns both the surface and the minerals, and he conveys the surface but reserves the minerals, keeps the minerals to himself. In that way, they have created this split estate, and one party owns the surface and the other party owns the minerals. Now, when we talk about the surface estate, we're basically talking about what you can see. The surface can be farmed, it can be ranched, and it can be subdivided. But the mineral estate is everything that's below the surface. Things like oil, gas, sulfur, uranium, coal, copper, those kind of things. So let's then look at who do we lease from if we have a different person that owns the surface and a different person that owns the minerals. And the answer is we always lease from the mineral owner. We lease from the mineral owner. We do not take an oil and gas lease from the surface owner because the surface owner does not have the right to do anything with the estate, with the mineral estate. So we take a lease from the mineral owner. What do we get from the surface owner? Well, we don't really do anything for the surface owner. We don't need to pay them a bonus payment. We don't owe them a royalty payment. The lease is going to be signed by the mineral owner, and the mineral owner is going to be the one entitled to bonus payments, delay rental payments, and royalty payments. So the question is, do you have to get permission from the surface owner in order to drill for the minerals? And the answer, surprisingly enough, is no. We don't have to get permission from the surface owner because under the law, there's a concept called the dominant mineral estate. And what the dominant mineral estate says is that the minerals are dominant to the surface estate. In other words, if there is a conflict between the rights of the surface owner and the rights of the mineral owner, the rights of the mineral owner trump the rights of the surface owner. So if we want to have development of minerals, and then that's going to require us, that's going to enable us to use as much of the surface as is reasonably necessary to drill and develop for the minerals. There's nothing in the law that says that we have to compensate this surface owner. But do we compensate the surface owner? Yes. And the reason that we compensate the surface owner is because we don't want to end up on 60 Minutes where Anderson Cooper knocks on your president's door and says, we have this little lady surface owner, and she said you didn't pay her anything, and y'all just came on and used her land to set up the rig and everything and to develop the minerals. And then the president of your company is going to have to explain to Anderson Cooper, yes, Anderson, under the dominant mineral estate, a theory of a principle of oil and gas law, the mineral estate is dominant to the surface estate. So therefore, legally, we can use as much of the land as we want to. How is that going to play to the American public? Not very well. And so what we do is we do give money to the surface owner, not because we're legally required to do so, but because we want to have a good ongoing relationship with the surface owner. And we can't have that if they're mad at us. So if they're mad at us, they can meet us at the gates with guns or stick their dogs on us or who knows what else. So we will negotiate with the surface owner. So why does the law have this set up? Why is this in favor of the mineral owner and the surface owner really has no choice? Well, the reason is, remember that the state's interest is in making sure that its citizens are independent, that they are able to provide for their family without having to rely on the government. And so the federal government says, look, if we allow this surface owner to prevent this mineral owner from drilling for their minerals, this is a possible revenue source so that the mineral owner could provide for themselves. If we allow this person to block it, then these natural resources are never going to be developed, and this person may have to rely on the state to support their families. So that is the concept between the dominant mineral estate. And all it says is that the mineral estate is dominant to the surface estate. So the mineral owner can use as much of the surface as is reasonably necessary without having to compensate the surface owner. Now, there are certain states that have state statutes that say you have to pay the surface owner something. One of those is, or you have to actually negotiate with the surface owners, and one of those is in Oklahoma. Leslie, you were asking about Oklahoma. So the Oklahoma Surface Damages Act requires that you do have to approach the surface owner and make a reasonable bargain, a reasonable offer for them to let them use the surface. Now, if they refuse, or if they say, I want $1 million or some unreasonable sum, then the oil and gas company has done all they need to do under the statute. All they have to prove is that they attempted to make a reasonable offer to the surface owner, and the surface owner rejected that offer. So what we would say to the surface owner is, look, either we're going to pay you so many dollars per acre and we're going to drill on your land, or we're not going to pay you so many dollars per acre and we're still going to drill on your land. The end result is the same. The only thing you need to decide is, do you want compensation for it or do you not? Now, other states have started to follow this, so you really need to learn the statutes of the states that you are working in. So that is the dominant mineral estate. So now you know the surface can be owned by someone and the minerals can be owned by someone different. But let's look at an example of chaining title. And this time we're going to use the fee simple absolute, that both the surface and the minerals are used by one party. And we're going to use an example from my great-grandfather. So these are made-up names. This one isn't. My grandmother's name is Laura, but the rest of these are made-up names. So let's say my grandfather dies, and he leaves 25% of his interest to his 4 kids. Peter has 25%, Luke has 25%, John has 25%, and Laura has 25%. So when he conveys the surface and the minerals, he's conveying 25% of the surface to each of them and 25% of the minerals to each of them. Now, what Peter could do is he could take his 25% interest and he could convey it to Reagan. And then Reagan would own 25% and Peter would own nothing. So at this point, the surface and mineral ownership would be Reagan 25%, Luke 25%, John 25%, and Laura 25%. Now, Reagan can take his 25% and he can convey it to Bush. Now, Bush owns 25%. Luke owns 25%, John and Laura. And then he conveys to Lincoln. Lincoln owns 25%. Lincoln conveys to Kennedy. Okay, so these are all links in the chain of title. Let's say that Luke did the same thing. He took his 25% interest and he gave it to Ford or sold it to Ford. Ford then conveyed it to Ike, and then Ike conveyed it to Washington. These are the chains of title that we're talking about. So at this point in the game, the surface ownership would be Kennedy, 25%, Washington, 25%, John, 25%, and Laura, 25%. And the mineral ownership would be Kennedy, 25%, Washington, 25%, John, 25%, and Laura, 25%. So pretty simple when you keep the surface and the minerals together. But let's look at what happens if we separate out the surface from the minerals. And this is a situation where they would usually say, I'm going to reserve the mineral interest and I'm going to grant a surface estate to someone else. That way, if there's ever any drilling for oil and gas, the person that owns the minerals is the person that's going to get the compensation. So let's look at another one of these, same fact pattern, but this time Peter conveys his 25% interest in the surface to Kennedy. And he takes the mineral interest and he conveys half to Carter and half to Reagan. So right now, the mineral ownership, the surface ownership, first of all, is Kennedy 25%, Luke 25%, John 25%, and Laura 25%. Now, the mineral interest is going to be Carter 12.5%, Reagan 12.5%, Luke 25%, John 25%, Laura. But let's say then that Carter takes his 1/2 interest, or his 12.5% interest, and he conveys half to Clinton, and the other half he conveys to Jefferson. So now Carter no longer owns, and Reagan does the same thing. He conveys half of his half, meaning 6.25%, to Bush, and then the other half goes to Lincoln. This should be, oh, that's 1/4. A 3.125, let's just make this easy. We're going to make that a half, and this is going to be a 6.25. I was getting fancy on you. So right now, at this point in time, the mineral ownership is Clinton, 6.25%, Jefferson, 6.25%, Bush, 6.25%, Lincoln, 6.25%, Luke, John, and Laura, John and Laura, 25% each. Oh, I'm sorry. No, Luke is still there. We haven't done anything with Luke's interest. So it would be these guys, then Luke, John, and Laura. Is everybody with me? Okay. So that's when the surface and the minerals are segregated. So the surface ownership in this case would be Kennedy, 25%, Luke, 25%, John, 25%, Laura, 25%. And the mineral interest would be, just like we said, Clinton 6.25%, Jefferson 6.25%, Bush 6.25%, Lincoln 6.25%, and then Luke, John, and Laura with the remaining 75% interest. So that is an example of chaining title. Now let's back up a little bit. Before we get to the chaining title, what happens, as you may recall from industry overview, is that geology will go out and shoot seismic, and they will determine whether or not they believe in a given area there is oil and gas, the possibility of oil and gas. And so they will do their analysis, and they will decide whether or not there is a play here. The term is play. And a play is a term used to describe geologically similar reservoirs or oil fields. That is, oil fields or reservoirs that have the same source, the same reservoir, and the same trap characteristics. I'm sorry. Now, the play itself will determine how large the area is that we're going to use to consider for lease acquisitions. So geologists use different kinds of tools to do this. They look at data from previous wells, they look at seismic work, logs, and then from there, they decide whether there is a play here. Once they decide there is a play, they're going to pass this on to the landman. And they're going to tell the landman, here is where the reservoir is, or here is where the play is. I want you to go and lease everyone that's open of record. Open of record means there hasn't been any lease recorded yet. Okay, so we can see here that we can go, this is going to be section 29 at the north half of 5 north, 4 west. Okay, so with that in mind, we know that we need to find out if this property has been leased, and if not, we need to know who the mineral owner is so we can go lease on it. So the first thing we do is we go to the county courthouse. Now, when we go to the county courthouse, this is the way they arrange their records. They have a grantor index and a grantee index. So if you sell your house to me, you would be the grantor and I would be the grantee. So we're going to take that instrument, that sale agreement of the house, and we're going to file it by your name, and then we're going to file it under my name. Okay, this is sometimes referred to as the reverse index, because instead of going for the grantor, the grantee, you're going to the grantee to the grantor, trying to figure out what the mineral ownership is. So this is how these records are organized, either under the name of the grantor or under the name of the grantee. So if you are a landman in Texas, how are you going to figure out who owns that north half of section 29? There's no way for you to look at a property description to get there. We don't know who the grantor is. We don't know who the grantee is. So what the heck are we supposed to do? So these documents are filed alphabetically, and we don't know whether who the grantor is or the grantee is. So what do we do? Well, the answer is we go to an abstract company. And an abstract company is, these companies basically saved our lives, because what they did was they went to the county courthouse every day and they made a copy of every instrument that was filed of record, and they indexed that, and then they filed it according to the legal description. So in order to find out who owns that particular acreage, I am going to have to go to this abstract company, and I'm going to ask for all their records. For example, in this case, Survey Block 32, Section 8. I want all their records. What they're going to give me is this index of all the records, and behind that is going to be the physical record itself. It's going to be a copy, but it is going to be the actual physical record. So you could either sit in this abstract company and start going through these instruments, but these people are trying to make a living, so they are going to require that you make, that there is a charge, an hourly charge, to sit in their office and look at their records. So what most landmen do is they will then, well, I'll show you that in a minute, but this is what an abstract is. This is called an abstract of titles. It's the index to every instrument. So we'll come back to that in a minute. So that's where the landman is going to have to go. He's going to have to start with the abstract company, because that's where the legal description is. So let's then look at the 10 steps that a landman would undergo now that we kind of have the background. And the first thing we do is, once geology gives us this plat, we're going to take a look at it, and we are going to do some research on our own. We're going to try to do as much research ahead of time as you can before you head out. So what I'm going to do as the landman is I'm going to look at my company's records. And I'm going to also use some resources known as Dwight's PI. PI stands for Private Investigator. No, it stands for Petroleum Institute. You see, every well that's ever been drilled in the United States has an API number, an American Petroleum Institute number. And so therefore, we can look at a system like Dwight's or Dwight's PI system, and we can see, are there any wells out there? What is the production on those wells? Are the wells still producing? We may even have some old land maps in our records that would tell us who these owners are. And we can also look at state production reports. Every state has a website that you can go and look and see what the production is in a given area. So we're going to check all that out before we even get in our car to head to the county courthouse. And that's step 2, is that we then go to the county courthouse. This is the one in Monahans, county seat of Ward County. This is one of my students took for their field trip report. And so what I'm going to do is I'm going to head to the county seat. I'm not going to go to the clerk's house, the clerk of court's house yet, or the county clerk's office yet, because I don't know who the grantor is and who the grantor is. So I'm going to then look in, and what I've done here is just go to Google, and I'm looking for an abstract company in Ward County, Texas. Now there's Pioneer Ward County Abstract Company, and this title company, Elliott and Waldron Abstract Company. So how do I know which one of these to pick? Well, usually I'll have a broker in the field, and the broker is someone from that area, and they will be able to tell me which one is the better abstract company. But if you don't have that, if you're just the landman going in on your own, you're just going to pick whatever abstract company. You might call them and say, how much do you charge to sit in your room, and whichever one's cheaper. That might be the way to go. But you go directly to the abstract company. And remember, we said the abstract company has everything filed by legal description, not by grantor and grantee, but by legal description. So what most landmen will do is they will copy or put on their run sheet these notes. So this is an index of every instrument that is in back of, this is the index, and in the back of this is every instrument that's ever affected this particular property. So most landmen would look at this and they would create what's called a run sheet. Now, a run sheet is basically you're taking the information from here and you're putting it into your own sheet. So here you see we have the, let me go back one so I can show you. Here is the name of the grantor, here is the name of the grantee, and then here's the description. This is a conveyance of all. The kind of instrument is a quitclaim deed. That's a Q right there, quitclaim deed. And then the date is 7/22/93. That's the date of the instrument and the recording date. And then it'll give the volume and page for where this particular instrument is recorded. So as a landman, I'm really interested in the volume and page number where every one of these is located. But I'm going to make sure I also use the grantor and grantee. Every bit of information that they've given me here, I'm going to write down on a separate piece of paper known as a run sheet. Now on the run sheet, what we're going to do is we're going to write the volume and page number from here. Remember, from here. That's where we start, because we're going to need to do something called pulling books in a minute. But I'm also going to capture the other information they have. Now this is not the same, okay? This is an example of an abstract of titles that's not the same as this run sheet. And you'll see the grantor grantee from here is W.L. Walkler to T.D. Montgomery et al. So I'm just going to go through and write down the volume and page and as much information as I can from this index as possible. And then once I have this done, this is called my run sheet. Actually, the word run sheet, the term run sheet, is used differently by different people. Some people call this the run sheet. Some people call the actual notes that you take on a legal pad the run sheet. So don't get too hung up in the titles, but this is an example of a run sheet. So once you have the run sheet, what you're going to do is go to the county courthouse and do what we call pulling books. Now, the reason we call this pulling books is because the books are on shelves. I used to have the books are on shelves, and the shelves, and they're like, the books are on shelves, and under the shelves, they have these ball bearings. It's like a drawer, if you will. And you can literally slide open the book pull on the book and it will come out of this sleeve. It will roll out of this drawer-like thing, and then you can read that book there. So it's called pulling book because you're physically, these books are filed on their side, and then you pull it out. There's like ball bearings underneath it, so it rolls out. You look at what you want, you analyze what you want, and then you put it back in. So that's the terminology for pulling books. The next thing we're going to do is, as we look at each instrument, or what the landman is going to do, is that he's going to interpret the instruments. So he's going to look at what type of deed it is, a warranty deed in this case, and he's going to make sure it has all the elements to be a legally binding deed. He's going to see, is there a grantor? Here's the grantor. Is there a grantee? Here's the grantee. Is there consideration? Consideration is what makes a contract legally binding. And in this case, they're saying it's the sum of $10. Now, the court doesn't really care what the consideration is. They just care that there was consideration. So most people won't put the actual figure of what the consideration is because it's really nobody's business. We'll make sure that we have a granting clause. Has granted and conveyed. All you need to say is A conveys to B. And then we have a legal description here. Make sure that it's executed and make sure that it's acknowledged. That means a notary public has said the person who signed this instrument is who they say they are. That's an acknowledgement. So the next thing we have to do, once we know that we have all of the valid elements for an instrument, we're going to look at key language in this instrument. And what we're looking for is we're trying to figure out what is being conveyed. Were minerals being conveyed, or was it a royalty interest being conveyed? So this is a very important distinction for you to make. So when we talk about minerals, what the language will be in that instrument will be oil and gas. I convey oil and gas in or under. That's a conveyance of the minerals. So it's defined as all the property interest under the earth, and it includes the executive right. That means the mineral owner has the right to execute or sign that oil and gas lease. They have the right to the bonuses, and they have the right to the rentals. The instrument itself will usually use the term minerals, and it will usually say oil and gas in or under. The next kind of a conveyance is called a royalty conveyance. Now, this is what you see when you see a royalty deed. So I want to explain this concept to you of the non-participating royalty interest owner. If you only own a royalty deed, if you only own through a royalty deed, the only thing that you're getting is not the minerals, but a right to a share of the royalty fraction of the lease. So until there's a lease, you don't really own anything. But it might say something like a 1/2 royalty interest. So that means if you have a 1/8 lease, 6.25% of this, half of 12.5, is going to go to this royalty owner. So whatever the mineral owner negotiates, if someone has a royalty interest, a separate deed called a royalty deed, then a portion of whatever the fraction is going to go to this royalty interest owner. This is called a non-participating royalty interest owner. And to give you an example, let's say Dad has a son who's struggling financially. And Dad, doesn't want to give up his mineral interest, so he says, okay, son, I tell you what I'll do for you. I'm going to convey to you a royalty interest only. And then if there is ever production on this property, you will be entitled to a portion of whatever royalty is in the lease. So I want to make sure you understand the difference between the royalty fraction in a lease and a royalty interest through a royalty deed. So the buzzwords that the landman is looking for in that case is, if it's a royalty interest, it's the right to receive payments, royalty payments. There's no executive rights, so the royalty owner doesn't have the right to sign a lease. They don't really have any other right to any other lease payments, not the bonus, not the rental, not the shut-in rental. And they're called a non-participating royalty owner, or I've also seen this called a non-participating revenue owner. The language in the instrument will say royalties, or it will say oil and gas produced and saved, or sometimes oil and gas produced, saved, and marketed, and the fraction size would be less than 1/4 interest. So this is the most important part of what a landman is doing. They're going through and looking at instrument by instrument and saying, what was conveyed here? Was it a mineral interest or was it a royalty interest? And as far as the landman is concerned, if it was a royalty instrument, he pays no heed to that. He is only interested in the mineral owner, because it's only the mineral owner that can sign that oil and gas lease. And also keep in mind, the landman is under a time pressure, because the first person that gets the lease is the first person that's going to record that lease, and they're going to be the owner of that lease from that point forward. So he's not worried about this royalty interest. Now, when we get to the title examination by the attorney will take his time and analyze each of these provisions and figure out what the mineral interest owner's percentage is, what the royalty interest percentage is, and what the surface, I'm sorry, not the surface interest, but the royalty fraction in the lease. Okay. So the other thing that we're looking for is how to interpret these instruments. And one is that when they use the word of in a fraction, when you say I'm conveying 1/2 of my 1/4 interest, that means to multiply. So you're multiplying 1/2 times 1/4, like that. Now we can break this down into decimal forms, and 1/2 would be a 0.50, right, times 0.25 for the 1/4 interest. And that is going to give us the interest in that lease, which is a 0.125 or 12.5% mineral interest. So the buzzword here is of. Anytime you see the word of by itself, that means that you need to multiply. Now, the other kind of use of the word of is if it says out of. That's different from just the word of. If it says out of or from, that buzz language is subtraction. So if I say 1/4 out of 1/2, what I'm really doing is I'm deducting 1/4 from this 1/2. So 1/2 minus 1/4. And then we can break that down into decimals to get the answer, 0.50 minus 0.25. And then that's our answer, is a 0.25. Okay, so once they have all this done, once they've done all their research, they're going to create this chain of title. So this is one that's typed up. They went instrument by instrument. They have the assigner's name, the assignee's name, and then they say what was conveyed. And then they're making sure that there is no what we call stranger to title or defect in title. In other words, once we have all this written out, we're making sure that the last person that owned it, Elton Parish and Mabel Lee Parish, that they are the ones that convey it next. So now we have Elton Parish and Mabel Lee Parish conveying it to Mabel Lee Parish. So this next instrument needs to start with Mabel Lee Parish. Now let's say it starts with Merrill Lee Jones. Mabel Lee Jones showed up out of nowhere. We had a Mabel Lee Parish, now we have a Mabel Lee Jones. So this Mabel Lee Jones becomes what we call a stranger to title. It's kind of like, where did she come from? And when you have a situation like this, now you leave the county records and you go to other records in the county courthouse to identify these gaps on title. And one of them is the probate records. You know, maybe this person died and the new owner is acquired the interest through probate, or maybe it was through marriage, like maybe Mabel Lee Parish got married and she's now Mabel Lee Jones. Now I need to find that, verify that in the marriage records. Or maybe it was a situation where there was a mortgage. And if it's a mortgage, maybe the property was foreclosed on. Let's see, I have a question here. Is a signer an assignee referring to mineral interest and grantor and grantee referring to a royalty interest? That's a great question. In this case, let's see what it's saying. Deeding undivided 1/2 of a signer's interest into the minerals in lots 3 and 4. I would not have used the words grantor, assigner, and assignee here. Really, that's only used when you're conveying a lease, an assignment of a lease, when you're conveying interest in a lease. So when your broker goes out in the field, he's going to be taking these under his name, and then when he's done, he's going to assign it to your company, and he would be the assignor, and we would be the assignee. This, I would rather see you use grantor, grantee, especially because we're talking about minerals and not a royalty interest. Good question, Monica. Okay, so back to strangers of title. Now, one thing that some landmen do that's a really quick way to do it, but it's not very accurate, is they'll just go and look through that index and see if there's any oil and gas leases in it. And if there's no leases in it, then in that case, they will then go and lease the mineral owner, whoever is shown up as the mineral owner in the abstract of title instrument. So that's a shortcut. Sometimes you'll hear someone say, I'm just going to do a leasehold search. And so I wanted you to know what that was. Okay, so I guess we already covered this as far as the gaps in title, but just to give you another example, if the United States government conveys to Lincoln and Adams and Bush, and Lincoln conveys his full interest to Carter, and the next person that we see in the chain of title is Clinton, Clinton is a stranger to title because we don't know where he came from. This should have been from Carter to Clinton. There should be some designation from Carter to Clinton. So this is a stranger to title, or it's also known as a gap in title. And that's when you would go back and you would look at the other records, the probate records, the marriage records, and the mortgage records. So then you submit this to the company landman, and they give you the yay or the nay to go and negotiate it. And then from that point, you go out and negotiate with the mineral owner, and you negotiate the oil and gas lease. So these are the steps that a landman would take in order to run the chain of title. They would first of all prepare. The geology is giving them where they think the play is. They would prepare, they would check out all their company records. They would look at any internet resources they had, like state production reports or Dwight's PI, and try to gather as much information about that area as possible. They may even have old land maps that would say who the last owner is. Then they would head out to the county seat, but not to the clerk's office yet. First, they're going to go to the abstract company. And the reason we don't go to the county seat first is because they're arranged by grantor, grantee, and we don't know what either of those are. But if we go to the abstract company, they have every instrument that's ever been recorded in the county clerk's office organized by legal description. So we're going to spend some time in there, not very much time because they charge by the hour. By the way, if, I don't think this is that common anymore, but what we used to do for the attorneys, rather than have them go out and wait and pull books, is we would give them what we call an abstract of title. And an abstract of title was just a copy of every instrument that was in that chain of title. So we would send that to the attorney. Then the attorney doesn't have to drive back and forth to the county seat, and he can take his time and go through each of those instruments and analyze them. So this isn't done that much anymore because there's so much available digitally. But this used to cost like $10,000 to do this, $15,000. So, you know, you're saving time by having to stay in the abstract company's office and travel time back and forth while your attorney does that. Okay, so I'm going to go to the abstract company. I'm going to write down, using that index for that particular property description, I'm going to write down the volume and page. and I'm going to write that down on a run sheet. I'm also going to have the grantor's name, the grantee's name, the recording date, the recording instrument, etc. I'm going to have all that in there. And then I'm going to head to the county courthouse and I'm going to start pulling these books. I'm going to pull these books out of their little shelves. They roll out. I'm going to open it up. The volume's clearly marked. I just go to the page and then I start analyzing or interpreting that instrument. And I'm looking for, you know, all the, it's got the grantor, the grantee, the consideration, words of grant, etc. And then I'm also seeing, is it a conveyance of a mineral interest or of a royalty interest? That goes into the interpretation of the instruments as well. And then I start chaining title and I identify where there's any gaps in title. So if we went from Lincoln or Carter to Clinton, and we don't know where Clinton came from, then I'm going to have to go to my probate records or my marriage records or my mortgage records. Then what the landman will do will compile an ownership report to the company landman, and then using that report, they will go out and contact the mineral owners to get an oil and gas lease. So that is the 10 steps. So let's look at what we talked about. We started with a review, and we talked about in the review how to record an instrument, like going to the county courthouse. And then we talked about what we mean by running the chain of title in the overview part of it, running title. And then also we looked at what letters patent are. And then we gave you a little bit of insight into what happens when a different person owns the surface estate than the mineral estate, that's called a split estate. And in that case, the rights of the mineral owner trump the rights of the surface owner. And then I actually showed you kind of some sample chains of title. And then we looked at the actual 10 steps to running the chain of title. But before that, we talked about the problems with the abstract or the county records, is that it's by grantor and grantee. And so you have to go to an abstract company. So once you understand that that's the overview, the first thing you're going to do is you're going to prepare yourself, get as much information done as you can from your desk. So that means looking at all your prior records, looking at P.I. Dwight's, looking at any other internet systems that you have that will give you information. You can also look at state production reports. I'm going to gather as much of that information as I can before I head out to the county seat. And once I do that, then I head out to the county seat. And the county seat, I will then go to the abstract company, and then I will start making my run sheet, and then I will start pulling the books. All these process to go through, interpreting the instruments, and then I'm going to make sure there's no strangers to title in it. And let's see, where do we end up on these? And then at the very end, we are going to contact the mineral owner and negotiate that oil and gas lease. So that wraps up this presentation on title examination, running the chain of title. So does anybody have any questions about running this chain of title or about this presentation? Any questions at all? Okay, here's a great question. All right, so the question is, what is the difference between, I'm going to write these out here. Sorry, let me see. I'm going to write this out so it'll be clear to everybody. What's going on? Oh, I think I can do it down here. Okay, so here's a question. What is the difference between a conveyance, let's use this next page, a conveyance an assignment, an and the division order. Why do you record assignments and conveyances and not DO? Okay. All right. Great question. All right. So a conveyance, first of all, there's a distinction between when we're talking about tangible and intangible property is what we call them. You've got real property and you've got personal property, but there's a further division that's known as tangible property versus intangible property. So when you're dealing with tangible property is anything that you can feel, see, touch, experience with your five senses. So when we're talking about real estate, that is something tangible. That is something that you can go out, you can see your grass, you can touch the dirt, you can smell the earth. That is a tangible conveyance. And so when we're dealing with tangibles, that is going to be done as a conveyance, usually by deed, tangible. But when we're dealing with something that's intangible, that is something that you have to understand with your mind. You can't feel it, see it, touch it, smell it. An example of this would be a right-of-way. So a right-of-way is a intangible. And so you could say, well, where is your right-of-way? And I would go out to my backyard and I say, well, here is the cable right-of-way. And you would say, I don't see anything. I just see grass and dirt. Well, it's not anything you can see or touch or feel. It's something that you have to understand with your mind. And the understanding is that the cable company has a right to come onto this property to fix the cable. There's nothing that you see, feel, hear, or touch with that. It's all in, you have to understand it with your mind. Well, in the same way, that's what an oil and gas lease is. An oil and gas lease is considered intangible real property. That means that if I said to you, where is your oil and gas lease, what would you do? You would take me out to the property and you would say, here is the lease. And I would say, all I see is dirt and grass. What do you mean this is a lease? Well, this gives the oil and gas company the right to come onto the property. Okay, but I don't see anything. Where is the lease? And then you would maybe hand me the physical written instrument of the lease. And you would say, here is the lease. And I would say, so I'm going to drill on this piece of paper. Is that what you're telling me? So whenever we're talking about something that you have to understand with your mind, like a right-of-way, that is going to be an assignment instead of a conveyance. So that's why you see an assignment of oil and gas leases or an assignment of working interests. Okay, so that is the distinction between the conveyance, that's usually a deed like a general warranty deed, special warranty deed, or a quitclaim deed. That's when we're talking about real property that you can touch, the actual physical earth. But when we're talking about conveying something that you have to understand with your mind, that's not the actual earth, then you're going to use what's called an assignment in that case. The division order comes once there is actual production. Once there's actual production, the title attorney will figure out who owns what percentage of the production from this well. And then we will send those instruments stating what the production is, what their decimal interest is, and ask them to sign it. And what we're wanting them to do is to sign it so they can verify that the decimal interest that we're using is correct. The reason that the conveyance instrument and the assignment are recorded and the division order is not is because the assignment and the conveyance is a transfer of interest. So in other words, we're transferring the real property from one owner, from the grantor to the grantee, or we're transferring the intangible property, the oil and gas lease, from one party to another party. So because it deals with a transfer, that's when we have to record it. And that's what makes that chain of title. Every transfer that's recorded is what the landman is examining to figure out who the mineral owner is. So does that make sense, Monica? Kind of a lengthy explanation, but I want y'all to understand the distinction between a deed and an assignment. That's a really common question I get. and it all depends on how the property is classified. Both real property, but one's tangible and intangible. When we are transferring interest, meaning who? Laura, the oil and gas company? Laura says, what about when we are transferring an interest? If the oil and gas company is transferring, let me see, but what about when we are transferring interest because we will have recorded documents to do so? Okay, hang on. Laura, I'm not sure what your question is. Can you resubmit it? Oh, when you're transferring an interest. Yeah, I gotcha. Okay. So if you are the party that's transferring an interest, yes, you will have a recorded instrument. You do not want to change your company records unless you have a recorded instrument, because if it's not recorded, remember, someone else could come along and file first, and they would be the owner of that lease. So yes, you do want, especially when we're dealing with leases, guys, you want to make sure that that lease has recording information on it. If it doesn't, you better send it back to the landman and say, get this recorded, because the risk is that someone else is going to record first, and they're going to be the recognized owner of the lease. Leslie says, what's the difference between warranty deed and a special warranty deed? So let's just go over all of these. I'm going to erase this. I don't see a way to erase it. But let's say we have a warranty deed. And then we have a special warranty deed that's also known as a limited warranty deed. Limited warranty deed. And then the last thing we have is a quitclaim deed. I just want to go over that with y'all because that's another type of conveyance of real property. So this is what we're dealing with: real property, tangible property. So the highest, these are all different levels of a guarantee of warranty, protection against defects in title. So the highest guarantee that title is valid is a warranty deed. A warranty deed has language in it that says we will protect and defend the warranty in this instrument. That means if you purchase property from someone and there is some kind of a title defect, you can sue that person because they are guaranteeing you that title is good. Now, in a warranty deed, the person that owns the property, let's say it's property A, they are saying, I guarantee you that I own this property and that everyone in the chain of title before me had valid legal title to the property, all the way back to letters patent or the sovereign. That's a warranty deed. That's what you want when you sell your house, because you don't want someone coming along later and saying, well, you know, they took this house from us and they never got our permission, and so therefore you need to leave. No, if you want to have peaceable enjoyment of your home, the instrument that you want to make sure you have is a warranty deed for a transfer of title, because that's your greatest guarantee against a title defect. Now, if we have a special warranty deed or a limited warranty deed, what that's saying is that owner A is saying, look, I can tell you that I own this property, but I can't vouch for every other person in the chain of title. But I can promise you that I didn't do anything. It's called buy through or under. I didn't do anything to jeopardize this property. In other words, I am the legal owner of it. I have not sold any part of it. I have not mortgaged any part of it. I have not leased any part of it. So that is the special warranty deed. It's limited to the acts of this owner. He's saying, I didn't do anything. I don't know about letters patent if there was a mess up there, but I didn't do anything. So that's the special warranty. And then the quitclaim deed, and I want to make sure you know that it is quitclaim deed, not quitclaim deed. That is one of my pet peeves. It's a quitclaim deed. And a quitclaim deed, there is absolutely no warranty of title. So the person in a quitclaim deed is saying, I don't know if I own this property, how I own this property, but whatever I own, I'm conveying it to you. So you do not want to use that for the sale of the house. But let me give you an example of when a quitclaim deed would come into play. When I finished law school, my mother-in-law was receiving a royalty check, an annual royalty check from a well in West Virginia in the amount of $12 a year. So she told me, Alice, I don't know why I get this check. I don't know if I own the property. I don't know how I own the property. All I know is my mother was getting this check from this oil and gas company for $12 a year for this well, and now I'm getting it. She said, I don't, if you can get rid of this, property for me, I will give you a full year's royalty payment. That's right, $12. So I could not pass that up. So I called the company that was on the check, and I said, look, this is my mother-in-law's property. She doesn't know how she owns it. She doesn't know if she even owns it. All she knows is her mother was getting this check. Now she's getting this check. What do I need to do? And the person told me at this company said she needs to execute a quitclaim deed. There's no guarantee of title whatsoever. She's not saying I own this property. She's saying if I own it, I convey it to the other relatives in the well. So that's what a quitclaim deed. So these are all just different degrees of warranty of title. So, or a guarantee of title. So starting with the warranty deed, that's the highest form. And then the next is the special warranty deed. That's limited to the acts of the current grantor. And then you have the quitclaim deed, and that is no warranty whatsoever. Yes, so Laura says we don't need to record the transfer because we already have the documents that are recorded. Exactly. Once it's recorded, it's recorded. You're done. So if you are using or transferring interest in your company, first of all, you don't want to make any transfers unless that instrument is recorded. But then you don't need to, all you're doing is trying to get your company records to match the clerk's records, the recordations in the county clerk's office. So you don't need to then send it in again for a second recordation. They've already taken care of that part of it. Okay, we had an issue. Here's another question. We had an issue recently, had a major title defect because a conveyance was recorded in the wrong county and we could not find the original. We had to get a certified copy of the document from one county to record it in the correct county. We almost lost that portion of the mineral interest because of that mistake. Great point, Monica. So when we're talking about recording an instrument, it's got to be recorded in the property where it's got to be recorded in the county courthouse where the property is located, not where the person is located. So in other words, if they live in Florida and they have a property in Oklahoma, it's got to be filed of record in the Oklahoma county because we're never going to find it, just like Monica's saying there was this huge defect on title. We're never going to find it if it's in the Florida jurisdiction. The only way we're going to find it is if it's in the county courthouse where the property is located. So in this case, yeah, I can imagine that you did go, that was a great way to solve it, was to go and find the conveyance from the other county courthouse, let's say the Florida courthouse, and then re-record it in the county courthouse in Oklahoma. Yeah, that's a huge mistake. So just remember that when you're recording these instruments, it's got to be recorded in the county courthouse where the property is located, not where the person lives. Does that make sense, Monica? These are such good questions. I'm so proud of y'all. Okay, here's Laura says, I need to get tax certificates on a property that shows no owner. A warranty deed was only filed in one of the counties when it is in 2 counties. The deed is about 60 pages. Do I have to pay for an original? Let me see, to send the other county to be recorded. You know what? See if the other county will accept a copy. Sometimes they will. Sometimes they'll, it just varies depending on the county clerk's office. So I would just call them, or you know what I would probably do? I would probably just send it without an explanation and let them have to respond back to me and say, now if it's 60 pages, is it what you're concerned about is the cost of it? Yes, the cost and time. Let me think this through. Okay, well, if they will accept, Monica's saying they will accept a certified copy from the other county. That's a great point. So the other county can give you what's called a certified copy of the instrument. And that other county will accept that. That's a great point. But I would file it in both. I know it's expensive, but just order it from the other county because that's the only way that you're going to be able to find it. It's just like it's recorded in Florida. You know, recording in one county is not going to, it's going to create a cloud on title for sure. Good questions. Anybody else? You are welcome. Any other questions, guys? Okay, so I'm hoping everybody learned something new about this process. But I just want you to recognize from a division order standpoint what the process is that a landman goes through and what a title attorney goes through. Because really part of your job is interpreting these instruments. You know, you do not need to be an attorney or a landman to interpret the instruments. That's something that you can do. Monica says, you are awesome, thanks. Thank you, Monica. Anybody else? Okay, well, if there are no further questions, I will let you go, and I hope you have a great rest of your day.